Tax exemption for tea warehousing, a High Court victory for agriculture. Introduction. In a landmark decision of Nutan Warehousing Co. P. Limited v. Commissioner Writ Petition number 12775 of 2019. The Bombay High Court has declared tea stored in warehouse to be an agricultural produce, exempting it from GST under Notification No. 12/2017 Central Tax Rate. This ruling in favor of Nutan Warehousing Company PVT Limited has significant implications for the taxation of tea storage and processing activities. Previously, the Appellate Authority of Advance Ruling (AAR) had denied the exemption, arguing that the stored tea underwent further processing, such as blending, altering its agricultural character. However, the High Court found this reasoning flawed, highlighting that minor processing and packing don't negate the essential nature of tea as an agricultural product. This decision clarifies the tax treatment of tea storage and paves the way for potential tax savings for warehouse owners and related businesses. It also underscores the importance of legal principles and precedent in tax rulings, emphasizing the need for careful consideration before denying exemptions. Times Facts. Nutan Warehousing, a company that leased its warehouse to MS Unilever, found itself embroiled in a tax dispute regarding tea storage. Unilever stored bulk tea in Nutan's warehouse, undergoing standard processing like procurement and blending for potential export. Nutan claimed this activity qualified for exemption from GST under a notification classifying agricultural produce storage as tax-free. The Commissioner argued the processing transformed the tea into a manufactured product, disqualifying it from the exemption. The Appellate Authority of Advance Ruling (AAR) agreed with the Commissioner, denying the exemption. Nutan, however, challenged this decision in the Bombay High Court, claiming the AAR made an error of law by misapplying legal principles and overlooking the tea's essential character as an agricultural product, even after processing. Times Issue. Whether tea stored in warehouse is an agricultural produce and exempt from GST under Serial Number 54, E, of Notification No. 12/2017 Central Tax Rate. Times Arguments. Petitioner's claims. I. Tea stored in warehouse is an agricultural produce. Nutan Warehousing Company, the petitioner, argued that regardless of standard processing, tea retains its essential character as an agricultural product. They emphasized that the processing undertaken, procurement, blending, and packing didn't alter the tea's nature for the primary market. 2. Exemption from GST under Notification No. 12/2017 Central Tax Rate. Nutan claimed their warehousing services were exempt from GST under Serial Number 54, E of the notification, which exempts storage and warehousing of agricultural produce. 3. Error of law by the Appellate Authority of Advance Ruling (AAR). Nutan contended that the AAR's decision denying the exemption was based on flawed reasoning and misapplication of legal principles. Respondents' claims. I. Processing changes tea's nature. The Commissioner argued that further processing like blending in the warehouse transformed the tea from an agricultural product into a manufactured one. This change in character, they claimed, disqualified it from the exemption under Serial Number 54, E. 2. Legality of AAR's decision. the commissioner defended the AAR's decision, asserting that it was sound and based on valid legal principles. They argued that Newton's interpretation of the notification and the nature of tea processing was incorrect. Times judgment. In a landmark judgment for Newton warehousing and the agricultural industry, the Bombay High Court declared tea stored in warehouse to be an agricultural produce, exempting it from GST under a crucial notification. This judgment, unraveling a complex dispute, hinged on several key points. One essential character of tea. The court recognized that even after standard processing like procurement, blending, and packing, tea retained its essential nature as an agricultural product. Minor processing for storage and transportation, they reasoned, didn't alter the tea's character in the primary market. 2. Error of law by the AAR. The High Court found the Appellate Authority of Advance Ruling, AAR, had made an error of law by misapplying legal principles and overlooking relevant precedents. The AAR, in denying the exemption, had concentrated solely on the processing aspect, neglecting the tea's inherent agricultural nature. 3. Issuance of writ of certiorari. Based on this error, the High Court issued a writ of certiorari, quashing the AAR's decision and granting Newton the exemption. This signaled a strong stance against misinterpretations of tax laws and underscored the importance of adhering to legal principles. 4. Impact on tax benefits. This decision has significant implications for warehouse owners and businesses dealing with tea storage. They can now claim GST exemption, potentially leading to substantial cost savings and boosting their competitiveness. 5. Clarity on agricultural produce. The judgment provides valuable clarity on the interpretation of agricultural produce in the context of tax exemptions. It emphasizes that minor processing undertaken for storage and transportation does not necessarily negate a product's agricultural character. If our video is beneficial for you, then do like, share and subscribe. Thank you.